No, not the correct time. But I know it was nighttime.
But you had an appointment with Mr. Dunbar to cut his hair, correct?
I didn't have an appointment. I just told him I was gonna come and cut his hair once I left the barbershop.
You said that you received about 20 to 30 calls from Miss Wombly while you were at Mr. Dunbar's house. Is that correct?
Yes, ma'am.
And did you answer any of those calls?
I couldn't really hear like the first couple, but for one, I had my phone on a charger in his living room, and he has a studio also in his house. So we was mainly in the back of his house, listening to the music, uh, getting ready for getting ready for his birthday celebration.
Judge, I'm going to ask the court to direct the witness to answer the questions because he is giving a narrative, not necessarily to the point of question. Sir, my question directly is, Miss Wombly, you indicated called you about 20 to 30 times while you were at Mr. Dunbar's house. Did you answer any of those phone calls?
Eventually I did once I went back and checked to see if I had any missed calls or not. Phone's on the charger.
So let me help you a little.
Okay.
So the first words out of your mouth, these would be yes or no, and then you can offer an explanation.
Okay.
That makes sense?
Could you repeat the question?
I received the answer. You said that you answered the phone call. Is that correct?
Yeah.
Okay. And how long were you on the phone with Miss Wombly?
Not long. Not long at all. Don't know how long was it.
Was it a few minutes or a few hours?
Say a minute.
You indicated that when you were ready to leave Mr. Dunbar's house to go get your clippers, that Miss Wombly was outside. Is that correct?
Yes, ma'am.
And when she was outside, did you have any fear?
Yeah. Yes, ma'am.
You were in fear of your life when you saw her outside of Mr. Dunbar's
I was
house?
in fear.
Full question, full answer for the record,
Okay.
otherwise it's not.
So wait till she finished. Okay, I'm sorry.
You were in fear for your life when you saw us.
The question is, when you exited Mr. Dunbar's house and you saw Miss Wombly outside of his house, were you in fear of your life?
Yes, ma'am.
And when you saw Miss Wombly, was she inside or outside of her car?
She was outside her car.
Was she with anyone or by herself?
She was by herself.
Were you with anyone or you were by yourself?
I had a lady friend that came there with me, but she wasn't there like with me. She had her own vehicle. She met me over there.
At what point did Miss Wombly show you the razor under her tongue? Was that at Mr. Dunbar's house?
Yes, 2 times.
You said that Miss Wombly tried to block you. Was that at Mr. Dunbar's house?
Yes, ma'am.
How did she try to block you?
The way how her car was parked. It was parked in front of my car.
Where was her front? What was her front bumper in relation to your front bumper?
A front bumper. It was her front bumper was it was in the front of her car. As her car was parked in front of my car.
How was her car parked in front of your car?
It was blocking me from pulling away.
So how were you parked in? Were you parked in backed in or were you front in?
Now I was parked straight in. I wasn't backed in nowhere. I was parked on the curve in front of his house.
Was there a car behind your car?
It was several cars out there.
My question is.
It was. Yes, it was.
So there was a car parked behind you that's not related to this incident, correct?
Say it one more time.
Your testimony is that there was a car parked behind your car that was not your car or Miss Wombly's car, correct?
That's right.
And you indicate that Ms. Wombly's car was in front of your car. Is that correct?
Yeah, it was parked in front of my car, but I couldn't make a straight pull off. I had to go around her car just to pull off.
So you were able to get around her car.
Yeah, eventually, yes, yes, ma'am. But as I was doing that, she kept pulling in front of me.
But you were able to establish a clear path away from Ms. Wombly's car, correct?
Not a clear path. Like I said, she was parked in front of me, and a clear path is me just getting in my car and going straight ahead. I couldn't go straight ahead. She was parked, like, if I went straight ahead, I would have ran to her car.
My question is, you were able to establish a way to get around Ms. Wombly's car at some point, correct?
Yes, ma'am.
And at that time, when you said that Ms. Wombly's car was blocked into your car, were you in fear of your life?
Yes, I was.
You indicated that Ms. Wombly was standing by your door. Was it your driver's door you're referring to?
She was standing, yes, ma'am. She was standing in the middle of the driver and going from my driver door to the passenger door behind me, pulling things out the car.
And when she was pulling things out of the car, what, if anything, did you do?
I picked up my speaker. I picked up my clothes I had because it was raining that night and everything was getting wet. I put some of it back in the car. Some things I left out there, and I got away. I proceeded to go leave the area.
So you left some of your items out in the rain.
Yes, ma'am.
And was that because you were in fear of your life?
Yes, ma'am.
You indicated that during the pursuit where Miss Wombly was driving after you, following closely, that you text her to leave you alone. Is that correct?
Yes.
So you were driving and texting at a high rate of speed while Miss Wombly was behind you. Is that correct?
I'm driving to a certain
Sir?
limit. I wasn't driving to just be safe. I'm driving to get away from someone that's behind me.
Is that a yes or a no?
I'm driving at a certain speed in order to not drive so fast because they had, like I said, they had just storm.
Your Honor, I'm going to say this witness is non-responsive.
Okay. So you drive off. Do you know the speed limit where you were at?
No, ma'am. No,
The
ma'am.
neighborhood, right?
It's a neighborhood.
Okay. So do you know, she's asking you how fast you were when you drove off.
Now, I wouldn't say I was doing the regular speed. I didn't drive real.
But we don't know what the
Okay.
regular speed is.
Okay,
That's
well, I would say, but in the neighborhood, it was, what, 25, 30 miles per hour?
Okay. And as you are driving at that speed, and please listen carefully, as you're driving at a regular speed limit, driving away from Miss Wombly, as you were at Mr. Dunbar's house, is that when you text her as you're driving away to have her stop following you?
No, ma'am. Not at that moment.
At what point did you text her to have you?
After she'd been following me 20 minutes or so after.
Okay. And who else was in the car with you?
No one.
Okay. At some point, you said that you got to Staten Road. Is that correct?
Yes, ma'am.
And when you got to Staten Road, what happened?
She still following me.
And is it raining at this time?
It's off and on.
So the roads are wet
Yes, ma'am.
and it's dark outside
Yes, it is.
and you're in fear of your life.
Yes, I am.
You indicated that you didn't want to go home because you didn't want Miss Wombly to know that you had just moved. Is that correct?
Correct.
You indicated that you were trying to avoid Miss Wombly. Is that correct?
Yes, ma'am.
How so?
Trying to hope that she stopped following me
How did you try to avoid Miss Wombly?
by pulling off.
When you were on the highway and Miss Wombly was on your bumper, driving very closely at a high rate of speed. How did you try to get away?
Tried to get in front of some other cars and uh, tried to. Uh, I picked up a little speed at a moment or two. Went from the streetway and got on the highway. Tried to get in front of some other cars and big trucks that was right there, hoping that she would give up or stop following me.
At this time, when you were on the roadway and then when you maneuvered into the highway, were there a lot of traffic on the road?
Uh, I can't remember, but it was quite a few cars.
Would you say more than 5 cars, less than 5 cars?
Can't remember, man. I don't want to give you no wrong answer, but it was a couple of cars. You could say more than one. You could say more than one. I know I seen a big truck. I seen I seen like I said, an 18-wheeler truck. I seen a family that looked at me when I was passing by, and the dad, I guess he said something to me because I guess I was going too fast in front of him with his kids in the car.
So there was a family with kids in the car, and you indicated that the father was he the driver?
Yes, yes, ma'am.
And he looked at you because you were going too fast. Is that correct?
Like because I was trying to swerve and trying to get in front of him or or get, just trying to make sure I ain't hit them, but also trying to lose her.
So there wasn't a lot of traffic on the road, correct?
It wasn't like how it be 2 or 3 o'clock traffic in Atlanta.
Objection, Your Honor. This is a question that's been asked and answered. He's said several times he doesn't remember. It's just more than one. So
I'll move on. You indicated that at some point you got to Greenbrier Parkway and that this is a loop, correct?
Yes, ma'am.
And so it's a loop. Is it correct to say that if you are in this loop, it only directs traffic to go one way, correct?
Once you get off the loop, you can go multiple ways, the left or right.
That's not my question, sir.
No, ma'am. No,
While
ma'am.
you are on the loop only allows you to go in one direction before you get on Greenbrier Parkway, correct?
The loop is, yes, ma'am. Is the loop when you get off the exit at. Yes, ma'am.
But you made a left turn, correct?
Yes.
So that was making an improper turn, correct?
No, ma'am.
So it's your testimony that you can make a left turn while there's a loop on Greenbrier Parkway, directing the traffic to go one way?
No, the loop is when you're getting off the highway. And then when you get to the point where you can either turn left or right, that's what I did. I made a left. The loop brings you off the highway.
You indicated that you tried to make a right turn, but at last minute you made a left turn, correct?
Ma'am. No, ma'am. I said I was getting ready to make a right, but I decided to make a left.
And that's what I said, correct?
No, ma'am.
So you decided to make a left turn at last minute, correct?
No.
So you indicated just now that you were going to make a right turn, but then you decided to make a left turn.
Thinking in my head, if I was to make a right, I'm going back towards the same way I just came. So I'm trying to get on the highway, which to me, it has more cars. I know how 285 can be. There's a lot of traffic, and I'm trying to lose her at that time.
So you indicated that during some time where Miss Wombly was in pursuit of your vehicle that she called you, correct?
Called me a couple times.
And you answered that phone call, correct?
Not every call.
My question is that you answered a phone call from Miss
Yes, ma'am.
Wombly, but you were in fear of your life.
Yeah.
And you indicated that she was crying, correct?
Yes, ma'am.
And you indicated that when you made a left turn, that's when Miss Wombly's car came full speed and ran into your vehicle, correct?
That's correct.
And you, at what lane were you in when she made impact to your vehicle? This is To further clarify, how many lanes does this Greenbrier loop allow for? Is it a 1 lane or 2 lane?
It's one, I want to say it's 2 lanes as you getting off.
And when you're saying getting off, are you, I need clarification. Are you referring to when you are getting on to the Greenbrier Parkway? What are you,
Getting off.
Yeah, just wait for her to completely stop and then
I didn't
speak.
hear his answer. This be it not.
so, Madam Court Reporter, she has to take down everything that we say. So it's really important that you allow me to finish my question and then you will answer and I'll allow you to answer your answer and then I'll ask you another question. So my question is, how many lanes does this Greenbrier loop have? Is it 1 lane or 2 lane of traffic or more?
That I'm not for sure, ma'am. I want to say 2. It could be 1.
And what lane were you in when Miss Wombly hit your vehicle?
I was in the lane where I can get off the highway at.
And that's the left lane, correct? So you can get off the highway?
I don't remember, man. I don't want to give you the wrong answer.
And when Miss Wombly's car made impact to your car, you left, correct?
No, ma'am.
What happened then?
As she wrecked into my car, I got out of my car, looked at my damage, and first I checked myself to make sure I wasn't injured. I got out of the car, I looked at my damage, and I told her that, man, this is too much. You're doing too much. And I got back in my car, and I left.
So you left the scene
Yes, I did.
and you called the East Point Police Department. You indicated that you received a report and they took a photo of the damage to your vehicle, correct?
She took my statement. Yes, ma'am. The lady took my statement and said that I should have stayed on the scene.
And you also indicated on direct examination that the officer also took photo of the damage to your vehicle.
She had to. She had a body cam on.
Okay. And did you present the police report, the officer's body worn camera, or any of that information from that East Point officer to your attorney?
No, I didn't ever go get it.
Did you present that evidence to the state?
This is my first time talking to someone.
So you never received the body worn camera, your statement, or the police report from that East Point officer?
At the time, I think it not after that day or two. My dad tried to go see if he can receive the report. My father.
Okay. And how did you contact the East Point Police Department?
I called him.
Did you call 911 or did you call?
911.
Okay. And do you have a 911 recording of your phone call to East
No,
Point
ma'am.
Police Department? What's your answer?
No, ma'am.
You indicated that after some time, this incident, that you spoke with Miss Wombly before, correct? Or after this incident, correct?
Yes, ma'am. She called me after a couple of days.
And when she called you, were you in fear of your life then?
I didn't really want to hear it. It was just like, blah, 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 the same thing what she been doing before.
Sir, my
But I still
question,
was in fear of my life, man. Yes, I was.
and that was a few days after the incident, correct?
Yes, ma'am.
You indicated that at some point, Miss Wombly came to your house. You gave her the address to your house, correct?
Yes, ma'am.
And this was your new address that you didn't want her to know at the date of the incident, correct?
That's correct.
You indicated that she was making payments to your Cash App, right?
Yes, ma'am. She made one payment.
And how much was that payment?
$40.
And do you have that Cash App
No, ma'am.
information that shows that she paid $40?
No, ma'am, I don't. My Cash App has been deleted since then.
After the East Point officer told you that you should have stayed on scene and made a report, why didn't you stay on scene and make a report?
I was in fear for my life, and like I said, ma'am, I'm a licensed barber and I'm a licensed CDL driver. So I did not know that when I wasn't in fault, I should have stayed on the scene. I was in fear of losing my license or getting points on my license, and I had to go to work the next morning.
Did you seek any medical attention?
No, ma'am.
Did you have any injuries?
No, ma'am. By me opening the door, I cut my finger a little bit.
Did you document that cut to your finger?
No, ma'am.
I'd like to go back to the pursuit of Miss Wombley to your vehicle. Can you describe 166? How many lanes is it?
Ma'am, I can't give you a correct answer. I want to say I know it's more than one lane.
Is it more than 2 lanes?
I would say, yeah, more than two.
More than 3 lanes?
I mean, can I speak to my lawyer? Because you keep asking me the same question. And I don't know, man. I don't want to give you the wrong answer. I'm trying to be, I am being truthful, but I know it's more than one lane.
At the time Miss Wombley hit your car, there were multiple lanes available, correct?
Yes, ma'am, because I know I was able to switch lanes.
And instead of going to the police precinct, you went home, correct?
Yes, I did. To get ready for work.
I'd like to talk about defense exhibit. I'm not sure what number this is, but this is the uh, temporary protective order that you submitted against Miss Wombley on I think October 10th, 2023. Under Civil Action 2023 CV 387313. Sir, are you aware that this case was dismissed on November 2nd, 2023 by Judge Manning?
Okay. It was dismissed because I wasn't to proceed the extra 30 days.
But at the time that you submitted this document, you were in fear of your life?
Yes, ma'am. It's been several incidents that I had with this female. Yes, I was.
I'm talking about this specific
Yes,
incident.
every incident.
I need a full question, full answer for the record. Please do not interrupt or allow her to ask a full question.
I'm referring specifically to this TPO from October 2023. 15 days later, this was dismissed, correct?
Okay, that's what it said. Yes, ma'am.
Okay. And it was dismissed because you failed to appear, correct?
I failed to get the notice to come back in.
Okay. I'd like to talk about this invoice. I'm not sure what exhibit, I think it's exhibit 5 from defense. Did you actually pay these repairs in this invoice?
Yes, ma'am.
How did you pay?
With cash out of my savings.
Okay. And do you have a receipt of you paying for $3,000?
Well, ma'am, that's my receipt right there.
I'm showing, do you have any documented proof that you paid from your savings account to this T&S Auto Care for $3,000?
Everything what you have in front of you, ma'am, is what my proof and my evidence of whatever that I did and done.
Okay, so you can't show that you actually paid for this, correct?
No, ma'am.
Okay. And you indicated that Ms. Wombley gave you $40 sometime afterwards. She put it in a cooler outside of your new address, correct?
Ma'am, she gave me 40 on the cash app, and she was bringing me more money to my house, as you see on that picture. when I told her to leave it in the cooler.
And how much money did she put in the cooler?
I think it was about the same amount.
$40?
Yes, ma'am.
So she paid you a total of $80, is that correct?
Yes. Yes.
And so to clarify, $80 is substantially less than a $3,000 payment for the damages to your vehicle, correct?
Right.
And I'd like to talk about the text messages, not sure what exhibit this is.
I think those are the ones where he made,
1, 2, 3.
1, 2,
Okay.
3.
On Friday, August 2nd, sir, where it says 12:04 p.m., towards the bottom of that message, it says, I will try to give you $40 when I see you tonight. There's a kiss emoji and a heart emoji. And it's your testimony that that $40 was to the $3,000 collision invoice that you received, correct?
Yes, ma'am.
But it's not listed in the text message exactly what this $40 is for, correct?
If it's not there, if you don't see it in front of you, no, ma'am.
Okay, so it could have been $40 for anything.
No, ma'am.
And the last exhibit, which is a photo of the damage to your vehicle, is this all the damage you sustained to your vehicle?
Yes, ma'am. And as you can see, it's the red paint on my car that came from the red van she was driving.
And sir, it does not reflect that in this photo.
Yes, ma'am. You look closer, you can see it real good.
Okay, so unfortunately, this photo doesn't show
Objection,
it.
Your Honor. Counsel's becoming argumentative with the witness.
Is the photo looks like it's black and white, is it?
It is.
No, it's not. It's a color photo.
Oh. Okay.
Okay. So if I'm unable to see the red paint on here, do you have any other photos that show clearly that it's red paint on this vehicle?
I have this one right here. I also have this one here.
Okay,
But
may
I
I
took it
see?
from my phone that day. that night.
Permission to approach?
Sure.
Have you ever been in a situation like this before?
No, ma'am. No, not to this extent.
Would you be surprised that you pled guilty to an incident involving using your vehicle against an ex-girlfriend?
That was everything that was dropped, ma'am.
Your Honor, I am showing to defense the defendant's guilty plea on 05 SC 36666 that he took a plea here in Fulton County to drug-related offense and aggravated assault involving Miss Sharday, Shardai Williams, common spelling. And the state would like to tender that into evidence under the business record certification that is the defendant's part of his criminal history that he pled guilty to, and it was taken from Odyssey, which is conducted in the regular course of business.
And what, is that going to be states one?
Yes, states one.
Any objection?
Well, first of all, it's not what the state is characterizing it as. It's not an aggravated assault. These are misdemeanors. And this is a family violence battery and a possession of marijuana. And the family violence battery is in reference to, is in reference to a hitting with his fist that has nothing to do with the vehicle. So I don't know if I'm looking at the right thing, or is there something else I should be looking at?
Sure. And I apologize, that's going to be 07SC59899, where the defendant pled guilty to aggravated assault, and I'm showing that to counsel. And that's State's Exhibit 1.
Okay, and the other one,
State's Exhibit 2.
I apologize. So states one is the 05 SC or the 07?
The 07SC,
Okay,
and then States 2 will be the 05SC.
thank you.
We're both admitted.
Yes, they're both admitted. I'm sorry, I was waiting if he objected, but I mean, I can take judicial notice if.
This is also a misdemeanor. This is a family violence battery. It's not an aggravated assault.
So is that 07?
This is 0722.
No.
This is 07SC59899. So this is also a family violence.
It was reduced, but he was indicted of aggravated assault.
So I'm sorry, I guess 07 SC.
Yeah.
598.
Yes,
Thank you.
59899.
Okay.
All right, so this is not a felony, it's a misdemeanor, so it's not, it's not admissible to impeach his character here. Just because he's indicted as a felony is not sufficient. He had to have pled guilty to a felony for it to be admissible. In this case, he did not.
Your Honor, defendant opened the door when I asked him, had this ever happened before? He stated no. This is for impeachment purposes.
And
Well,
07
That's an extremely vague question. Has this ever happened? And he's talking about he's been hit with a car. So if she wants to ask him a more specific question and, he lies, then by all means, they can bring in a prior conviction. But that's an extremely vague question because he's up here talking about he was hit with a vehicle, he was chased and basically almost cut with a razor. So if that's never happened to him before, I wouldn't be surprised. That's quite crazy behavior.
Well, no, he didn't say he was almost cut with a razor. He said she had one.
Well, anyway, he was threatened with the razor.
Do you want to just rephrase the question? Because I think you said, would it surprise you if you've been something affected, you've been in an event like this with another ex-girlfriend or something?
Mr. Bivens, have you been involved in an incident where you've used a vehicle to assault an ex-girlfriend before?
No, ma'am.
Okay, Your Honor, based upon that testimony, I'm using State's Exhibit 1 to impeach this defendant.
Okay.
Well, let me see her impeachment because there's nothing in there that says that a vehicle was used on an assault.
And I'm reading on the statement of the witness, which is attached to, to be more specific, Your Honor, this is 07SC59899. This defendant took a plea. It was initially charged as aggravated assault and it was reduced to family violence battery, which is a misdemeanor. And this plea was taken on November 19th, 2009 in front of Fulton County judge. And it has the plea of guilty statement of the defendant's signature and his attorney's signature at the same time. And in this particular case, this incident occurred on August 8th, 2007. The officer responded to an aggravated assault call, spoke with the victim, Ms. Sharday Williams, who stated that she and the father of her child, the defendant, were engaged in an argument when the suspect slapped her across the face with the open hand. The victim said that the suspect ran down the steps to the car and she followed. As the suspect left the location, he drove the car in the direction of the victim and hit her leg with the vehicle. The suspect was arrested and sent to the Fulton County Jail. And this occurred in August of 2007. Sir, are you surprised to hear that information I just read?
Well, Your Honor, I object. First of all, that has already been proven false because she came out and said that he didn't hit her with the vehicle. The only thing he pled to was slapping her in the face. And that's part of the reason why he only pled to a family violent battery and not to an aggravated assault. So
let me ask you, how do we know she said,
She's talking.
how do we know that she said he didn't hit her with the vehicle? I mean, I don't have a transcript from 07 or 09.
Well, he didn't plead to the aggravated assault. The aggravated assault, if she brought the indictment, which she did not purposely, because the indictment was stating that the aggravated assault portion of this was him hitting her with the vehicle. The family violence portion of it was him slapping her in the face. He only pled to the family violence, which is the slap in the face. It's purposely deceitful.
Your Honor, what I'm trying to establish is that this defendant on cross-examination indicated that he's never encountered a situation like this before. And what I'm showing is that not that necessarily he pled guilty to it, but that as a part of this case in which he was indicted for aggravated assault, subsequently reduced to family violence battery, the allegations are distinctly or are very closely aligned to the allegations in this particular case, that the defendant used a vehicle and he used it offensively against an intimate partner.
Easily the most outrageous legal argument I've ever heard. So now we're saying that allegation is impeachable? No, it's not. And she can't impeach him with an allegation. It has to be only a conviction. And he did not plead guilty to the aggravators.
So I will tell you that the indictment,
What?
so I'm taking judicial notice of the indictment, it was indicted on ag assault.
Yeah, but he only pled to.
Right, it was reduced. I mean, I know in negotiations it's reduced, so I'll admit it, or I'll take judicial notice of it, so I'll admit it.
All right.
And sir, you've been involved in a situation where you've offensively used a vehicle against an intimate partner, correct?
No, ma'am.
I got you.
Okay.
Stage one is admitted.
Thank you.
Can I speak, Your Honor?
No, you gotta wait for a question, okay?
Okay.
So this is not your first domestic incident involving a vehicle, correct?
If you have, no, ma'am.
Your Honor,
I
objection,
don't-
Wilson already asked the answer. He already said that it's not true. We already went over the whole fact that the accusation or the indictment, the charges were reduced because it was not true. And so for her to continue badgering him with the same question is badgering the witness, Your Honor, and I object. I object to the question.
His answer was no.
That's correct, Your Honor.
You said, is this the first, and he said no.
Well, I think that she confused with the question.
I don't understand.
Okay.
The court's clear, go ahead.
Thank you. One moment. At what point did you tell law enforcement that you were acting in self-defense?
I don't understand the question.
Did you ever tell any law enforcement that you were acting in self-defense as it relates to the incident that we're here for between you and Miss Wombly?
I was relating on self-defense. I didn't, my self-defense was getting away.
My question is, did you ever tell any law enforcement officers that you were acting in self-defense as it relates to the incident between you and Miss Wombly?
I don't understand. I don't understand the question or relating to what.
I'll ask it a different way. Did you ever tell the police that you were acting in self-defense?
Only person I told, no ma'am, was East Point, that I was getting, that I had my ex-girlfriend chase me down and I left.
Do you remember? Go ahead.
Okay, because I left and I was just scared, just trying to get home.
Do you remember being arrested?
When? Okay, yes ma'am. For the warrant?
Yes.
Yes ma'am.
And do you remember telling that officer that there was a woman in the car with you at the time of this incident and she was driving the car when Miss Wombly initially hit the vehicle?
That I don't recall. Like I said, I had my girlfriend there. She was riding with me at one time.
But you indicated
My new lady friend.
you indicated when I asked if anyone was in the car with you, you said that no, because your lady friend had her own car at Mr. Dunbar's residence, correct?
Correct.
But now you're saying that she was in the car at some point?
That had happened like earlier that day. That she chased me and my lady friend like a day or two before that.
Okay, did you tell the police that this incident occurred a few days prior to July 28th?
Yes, ma'am.
Okay. But you didn't say any of that on direct examination, correct?
What you mean about that?
When your attorney was questioning you, you never said anything about Miss Wombly chasing you and your lady friend days prior to July 28th.
Mention it to him.
Okay.
I didn't hear your answer first.
No, ma'am. I didn't mention that to him.
So are you aware that when you are arrested that in the back of the patrol car, there's video and audio?
I think that
I didn't finish the question.
Let me allow the question. I'll allow.
Okay, go ahead.
So are you aware that in the back of a patrol car that there is audio and video that records the interactions in the back of that car? Okay. So would you be surprised if there's video of you articulating that your female friend was the actual driver of the vehicle at the time Ms. Wombly made contact to your vehicle?
Oh, man.
You would not be surprised?
Oh, man.
Okay. So which one is it? Is it you were driving when Miss Wombly hit you, or was your female friend driving when Miss Wombly hit
My
you?
female friend was we was riding together a day or two before then when she tried to do something to her.
Were you afraid of your life at that time?
Man.
One moment.
Okay.
When Miss Wombly's car made contact with your car, was her car disabled?
I don't believe so, ma'am. I was just looking at my car, my damage, got back in mine, and I left.
And you were in fear of your life when you exit that vehicle to check the damage of your car?
Yes.
And where was Miss Wombly's car at the time?
She was out of her car, I want to say. So I think she was out of her car or hanging out the window.
And you saw her hanging out the window or outside of her vehicle when you stepped out of your vehicle?
Yes, ma'am.
Okay. And you previously indicated when she was at Mr. Dunbar's car, she showed you a razor under her tongue, correct?
That's correct.
But yet you still exited your vehicle and checked for damage before you drove off?
Yeah.
Okay. And did Miss Wombly follow your vehicle after you checked the damage and drove off?
No, ma'am, I don't believe so because I left. She wasn't behind me.
Okay. And who was driving at that time in your vehicle? Was it you or your lady friend?
Me.
How many times did Miss Wombly's car make contact with your car?
That one time when I just went twice. When she parked in front of my car, and when she ran into my car as I was making that turn.
So when you were at Mr. Dunbar's car, you indicated that she had blocked you in, but now it's your testimony that she also made contact with your vehicle as well?
Made contact meaning she was her car was right there at my car. So as you could say her car was making contact with my car.
And when you say it was close to your car, would you be able to walk between the two cars?
No, I don't believe so. You probably could. You probably can.
So it was not close enough that someone could walk through, correct?
No, ma'am. I think I probably could have walked in between of it.
So it was not making contact with your car. Her car was not touching your car, correct?
That, well, I want to say yes and no.
Define contact. Your Honor,
Can we define contact?
yeah, can we define contact for the witness, please? 'Cause I think.
Okay, let me show you. See my phone?
Right.
This is not contact. This is contact. Did the two cars touch? Touch, touch, touch.
Uh, I'm not that big. I mean, I'm not that small, but you or someone else could probably squeeze through
So
that.
the cars were not touching. Because if somebody could have walked through or did it, they weren't touching.
Just
I got it. Move on. Okay.
I can't really answer that.
Okay, so I'm letting you guys know that my sister's taking me to a birthday dinner at 5:30, older people. So, I mean, I'm just asking, are we gonna be,
I can move on,
I
Your
only
Honor.
live like,
This is
not-
the longest witness, Your Honor.
okay, okay.
So-
And the comfort break after 2.5 hours, Brian, 60
Yes,
minutes,
please, we don't-
5-minute conversation.
we don't
It won't
wanna
take
make the-
long, but just letting you know,
Yes.
maybe, all right.
I'm almost done with this witness, Your Honor.
Okay, yeah, we'll let Ms. Sanders take a break.
Okay, I'm almost done. Just one moment.
Okay, no worry.
Did you contact your insurance company after this collision?
At the time, ma'am, I had that which you as you pay as you go insurance. So at the time, no, because it went from the 28th of July to the 29th, and I only had paid for that day of the 28th.
Your answer is no, you
No,
did not
ma'am.
contact insurance
No.
company?
I think it's called Hugo Insurance, where as you pay as you go
Oh,
by day.
One moment. Did you ever seek a warrant when you spoke with East Point Police Department or any other officer from any other agency as an aggravated assault against Ms. Wombley for hitting your vehicle?
No, ma'am, I was told not to.
Who told you not to?
My public defender at the time she told me to gather all the information, and she also told me not to pursue the PTO that I had. The second one I had put on her.
Sir, this incident occurred on July 28th, 2024, and you were arrested on September 9th, 2024, correct?
But I was finna go down to downtown again and put another PTO on her when my public defenders told me not to do that.
Sir, from the time of the incident and when you were arrested, you didn't have a public defender, correct? You only received a public defender after you were arrested, correct?
Yes. Yeah. So I was gonna put a PTO on her after I got out of incarceration.
Okay, so from the 43 days from the incident and when you were arrested, did you try to seek a warrant at that time?
No, ma'am.
Okay.
I was trying to get money up to get me a lawyer or fix my car and pay rent. I lost my job at the time. I had spent 3 days in Rice Street working at Buckhead Meat, and I had got laid off for no call, no show, which I have statements from my supervisor that.
that's okay.
Thank you. No further questions.
Any follow-up?
No, Judge.
Okay, you can have a seat, sir. So we'll take a few minutes break for Madam Court Reporter, and you can bring the guy in here, so he'll be ready to go when we get ready.
All right, thank you.
I'll step down for a few minutes too.
You will use the bathroom, you can use it now. You gonna use the bathroom? This is Joseph Henderson, yeah? Come on, Greg. You can.
You know, well, she was talking about my whole child mama. Okay, it's me. If I had a paperwork in my car saying that I wasn't in my They missed it.
Yes.
They not handling the floor.
I mean, it's all right. It's not relevant. I was 20 years ago. No, 19 years ago. It's great.
You used to have C right there. Right here? Yeah, right there. No, something like that.
Gentlemen, please, I need to sign some paperwork from me. I know this for that's all of the bill. I just think a lot. I'm like, where is she going? She always telling me.
Yes, Miss Downtown. She the
Okay.
back.
If I can, if you want me to come back there, I can come back there, I just sign these stuff for me.
Oh, okay. It's for,
Tell this for on the counter we had this morning.
okay.
Yes, ma'am. Hey.
Are you in the building?
Yes, I am, but right now I'm trying to get Judge Manning to sign his paperwork for me.
Yeah, that's why I'm calling. The charge is calling me. She said come to courtroom 5D.
This where I am.
Okay.
Yeah.
All right, good deal.
Yeah.
Do you not see the car?
Yeah, we will talk, no, sorry. It's just me and the deputy.
Okay, so Judge Manning is there?
Yeah, he's going back to get her now.
Mr. Anderson, come on first.
All right.
Thank you.
Thank you, ma'am.
All right, bye-bye.
I'm gonna find this part. Oh, you may, okay, it's up. I'm looking for, that you have one. They here. Yeah. Yes, I'll be through here. The deputy went to the back to get her.
Oh, that was you went.
Lord, have mercy.
Just stay, sir, tell her to stay here.
Oh.
Well, we just got
a
witness out there.
It was the lady. Cause I just saw ABA, she's gonna come to me.
Unless she went down to,
Went down where?
the Swan.
Shit. They still.
They don't break down like a 5-minute break. Speed.
Good thing she signed the wish to do. Won't take all day.
We got like 2 weeks left, that's it.
I got my steps in for the day. For the day. Cause I was gonna go to Plan B. I was gonna email it to them. They have a side about this filing.
No. Oh.
All right. Where's the witness? Oh, I'm in trouble.
Not for me, because I don't have any clout.
Mhm.
You can take this witness stand, that black chair next to the TV.
All I asked you was a full question and split it. So I needed to finish this other earlier.
All right. Yeah, sit down. All right, can you raise your right? Can we start, Judge?
Yes, go ahead.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
All right, can you state your name for the record?
My name is Joseph Anderson, Joseph Warren Anderson.
All right, and how long have you known Daryl Bibbins?
I've been knowing Nondera for roughly 20
Okay.
years, a little bit over 20 years.
All right, and how often do you interact with him now?
I interacted with him at least probably every 2 weeks.
Okay, and do you know
I talk
Ashley?
to him probably every few days just to talk to him just about just stuff.
Okay, and do you know Ashley Wimble?
Yes, I do know.
All right, and how do you know her?
From them two dating,
Huh?
them two when they was together.
Okay, all right.
When they was together,
All right. And during that time that they were together, did you ever see Ashley be aggressive with Daryl?
Objection.
I'm sorry, go ahead. I
I'm
apologize.
just objecting to this line of questioning as to relevance.
So, I mean, is he just trying to be a character witness? Was he there that day?
No, he wasn't there that day. He's just a character witness. Yeah, he's just going to the character of Ashley,
Is it
and also testifying to the nature of the relationship between the two parties.
improper character with evidence, and also the defendant testified himself as to their volatile relationship.
All right, and so once again, under the immunity statute, it's not improper character evidence to bring in the character traits of the alleged victim if we're alleging that the victim is violent, and that's exactly what we're alleging.
Well, then relevance, this witness was not present at the date of the incident, and that's what we're here for.
Well, it's character witness, so he doesn't have to be there on the date of the incident. He just has to know her, and he knows her.
Okay, so here's the thing. Why is he going to try to testify about the character of the victim?
Well, he's going to testify to the character of both of them. And he's going to testify to the nature of the relationship because he knows both of them.
And again, my objection is based upon, we're here for an immunity motion based on July 28th, 2024. This has no relevance to whether or not the defendant acted in self-defense on that particular date.
Once again, Your
Yeah,
Honor, the
no, I
character of the
understand.
victim.
So go ahead,
Yeah.
but I mean, you're not gonna like, we're not starting like
No,
at
I'm
birth,
not.
right?
Exactly. Well, no, this is not, like I said, it's not going to be long.
All right, go ahead.
All right. And so would you go to their house sometimes?
Yes, sir, I do.
All right. And so did you see them interact with each other?
I did.
All right. And so what was the nature of the interactions between them?
In the beginning, it was all good,
Okay.
but then throughout time, it didn't turn out good.
And what do you mean it didn't turn out good? Could you describe to us?
Arguing, debative, arguing, stuff like that. I was
Okay. And who was arguing? Who was arguing and what type of behavior did you see?
I actually arguing with Daryl over some toilet paper. I go over to his house to get a haircut, sometime late at night when his shop closes and I get off work late.
Okay, hold on. So just answer the question. I don't need
That's
all
why I
that.
was over his house.
Okay.
That's all I need. You're over there. I didn't need no
Yes,
more.
ma'am.
Okay. And so who is doing the arguing and who?
The young lady, she was arguing with Daryl.
All right. And so let's just, all right. And so that's fine. How would you describe Mr. Bibbins' personality?
He's very humble. He's a very humble, laid back guy. He's always been a humble guy. I've never seen him any fights or any debates I just never seen him.
All right. And have you ever seen Mr. Bibbins have a negative interaction with Ashley, which you already stated you did? All right. And apologize. As far as Mr. Bibbins' relationship with Ashley, do you ever see that? Okay. How does Ashley keep Mr. Bibbins in the relationship as far as what you see?
Well, she tried to give him gifts and stuff like that to keep him under wraps or keep him under control and stuff like that. But she could be a very aggressive when
Hold on a second.
Oh,
Yeah,
where's
I
your client?
apologize. Yeah, I apologize, Your Honor. I just realized.
I
Can you
did
get
too.
Mr. Bibbins? He's actually sitting right outside.
I did too, but I looked over there. I was like, wait a minute.
I just realized that. So,
Did I do something wrong?
No,
No.
he's supposed to, Mr. Bibbins is supposed to be in here.
yeah, I thought that he was behind me.
We started with that question for
And
you.
yeah. I think he thought that the sequester applied to him.
Oh, yeah, no.
Yeah, sit up here, man.
All right, go ahead.
All right, you may continue. You may continue. So how do you believe that Ashley keeps Mr. Bibbins in the relationship with him?
Well, she like I said, buy him gifts, pay him gifts to keep him, I guess, under control or something like that. But Mr. Bibbins has always been a humble man and a mild-mannered man since I've been knowing him. I never seen him upset or aggressive or nothing like that throughout my whole life. I'm retired military, and we've been friends for over 20 years. He's been cutting my hair for over 20-some years, and that's how him and I interact, and we've been friends. And
Oh, all right. And how many times have you ever seen Miss Wimble harass Mr. Bibbins?
I think probably 2 different occasions, yes.
And what type of behavior did she display on those two?
She was very argumentative and aggressive. She was the aggressive one.
All right. And have you ever witnessed her do a drive-by the barbershop?
I did, yes, sir.
All right. And what happened during that incident?
I was getting a haircut, and then
Yeah.
she came by his shop.
Yeah.
He seen her, spotted her, we seen her standing when she drove by.
All right. And were they together at that time?
No,
And was that after this incident had taken place?
did incident, yes, sir.
All right. And did you know that Mr. Bibbins was previously arrested for family violence?
From that situation?
No, not from this situation, about 20 years ago. Did you know?
No, sir. I don't know anything about that.
Okay. And did you know his partner or anybody involved in that?
That's a negative, no, sir.
Does that change your opinion of Mr. Bibbins knowing that?
No, it's how Mr. Bivens treated me and my family. He cut my son's hair, cut my hair. He's always been a gentleman to me and my family. I have nothing negative. That's why I'm here to support him.
All right.
and whatever it takes to support him because he's a great guy to me.
All right, thank you. No other questions.
All right. All right. Cross?
Very briefly. Sir, you were not present on July 28th, 2024, correct?
No, ma'am.
Okay. You didn't witness the interaction between the defendant and Ms. Wombly, which brings us here today, correct?
On the day of question, is that
Yes.
the action? No, ma'am, I wasn't there.
Everything you know about this incident came from someone else, correct?
From someone else. I know what I seen.
No. On the incident we're talking about, the day that we're talking about that we're here.
Yeah, I've seen the pictures and I've seen
Oh,
the
well,
police
that's-
report. Yes, ma'am.
That's what she.
Yes,
yeah.
ma'am.
So you saw the pictures and things of that nature from this defendant, Mr. Bivens, correct?
Yes, ma'am.
Okay. And you didn't speak to Ms. Wombly after the incident that we're here for, July 2024.
No, ma'am, I would never speak to her.
Okay. And so you don't know how Mr. Bivens and Ms. Wombly's relationship was when they were alone, correct?
I know they was happy.
Okay, they were happy. But when they're having an altercation, a verbal altercation, you indicated that Ms. Wombly was aggressive, correct?
What I witnessed, yes, ma'am.
Okay. And you indicated that how long had it been dating to your knowledge?
I don't know, man. A few months, maybe. I don't know. Was it 6 months? But it was a little while. It wasn't no years and years and years, but it'd been a while. I want to say maybe 6 months, something like that, 2 years. I can't remember exactly.
So after the incident that you indicated Ms. Wombly got aggressive about toilet paper with the defendant, is it your testimony that you saw them back together after that incident?
Yeah, because they would argue and they did not argue. Yes, they was aggressive. She was aggressive that day, and then a few weeks later, I guess they was back together.
So you would say this is like a toxic relationship between the two parties?
Sometime.
Okay.
Yeah.
And you indicated that the victim, Ms. Wombly, drove by the barbershop a few days after the incident, correct?
Yes, ma'am.
And so can you just...
Yeah, it was a few days. It was after the incident. I don't remember exactly how many days it was after the incident. I don't know. Might have been a few weeks. I don't know, but we was at the barbershop.
So you just observed her drive by the barbershop,
Yes.
correct?
Yes.
Did she point a weapon at anyone?
No, I don't think so.
Okay. Was she just driving by the barbershop?
Yes, ma'am.
Okay.
Through the parking lot
Okay.
for where he works at. And I think Atlanta's pretty big.
Hold up. That's
Okay.
not a question.
You care about this defendant, right?
I care about his welfare, yes, ma'am, and I care about any innocent person.
Okay. And he told you his version of events, right?
I've heard his version and I've seen what my version is, what I've seen.
And I'm specifically telling you about, I'm specifically referring to July 28th, 2024. He told you his version of events that occurred that day, correct?
And I read the police reports, yes, ma'am.
Okay. And so you have Ms. Wombly's version of events from the police report, correct?
I've read it, yes, ma'am.
Okay. And you indicated that you would do whatever it takes to support him, correct?
Morally, yes, ma'am.
Okay. But at the end of the day, you were not present, correct?
On the day of question, or the day of the incident, no, ma'am.
No further questions.
Anything else?
No question.
Thank you, sir. You
Thank
can
you.
stay in here or you could leave, either one you want to do.
Yes, ma'am.
Okay. All right. Anything else?
No, Judge. Defense rests.
All right. So are y'all wanting to do a closing? Is anything from the state?
I have a closing, Your Honor.
Okay.
It's very brief. Your Honor, the state is asking the court to deny this defendant's motion for immunity. The self-defense by preponderance standard has not been met. What the court heard was the defendant's own testimony, which is inconsistent, uncorroborated, and contradicted by his conduct and his own words right before this court. The defendant indicated that he was in fear of his life at several times. He was in fear of his life when he was at his friend's house. He didn't call the police then. He indicated that when Ms. Wombly followed him at a high rate of speed, that he indicated that he was able to text her, yet he did not call the police. He indicated that it was a family and a father and their children in the back of their car, and the father even looked at him crossed because the defendant indicates in his own testimony that he was driving unsafely at a high rate of speed on a 2-lane road on Route 166 when the conditions were wet and it was dark outside. And yet when he indicated that the victim made contact with his car, he indicated that he was making a left turn. The state would ask the court to look at judicial notice. When you're making a left turn, you're in a far left lane. The defendant couldn't tell whether or not it was a 1 lane or a 2 lane, but he can remember specific facts about that date, like not having his clippers or that the victim showing a razor under the tongue. But we are here to determine whether or not he was acting in self-defense. He cannot remember specific acts that relate to his own self-defense claim. Your Honor, he does not remember what lane he was in. He indicated that he picked up the victim's phone calls at his friend's house. That when the victim showed the razor under her tongue, he still approached his vehicle when she was at his own vehicle, and he placed items inside of his car. But then again, he did not call 911, but yet he was in fear of his life. There's conflicting testimony from the own defendant whether or not there was a woman in the vehicle with him at the time of the incident. The defendant indicated initially on direct examination that he was with a lady friend, but that she drove away in her own car. However, on cross-examination, he indicated that at some point she was in the car with him. Your Honor, the defendant does not know who was with him at the car. Again, Your Honor, he also indicated that the victim blocked him into the car, but that there was enough space that someone could walk through the car, and he was able to drive away from Ms. Wombly at that time, yet did not call 911, yet he was in fear of his life. He also indicated that he was picking up speed, that there were big trucks, an 18-wheeler. There were quite a few cars on the roadway, and yet he was trying to swerve and get in front of those vehicles to get away from Ms. Wombly. Yet he did not call 911, but he was afraid of his life. He indicated that Ms. Wombly had been following him for about 15 to 20 minutes or longer, and sometimes he say 20 to 30 minutes or longer, yet he was in fear of his life, did not call 911, did not drive to a police precinct, to a fire rescue station. And yet, while Ms. Wombly was in pursuit of the defendant, in his own words, he answered a phone call from her, yet he was in fear of his life. He indicated that he didn't want to go home because he did not want her to know his new address, but days later, he's engaged in text messaging with the victim, and he even gave her his new address, but still had not contacted the police. He indicated that he contacted East Point Police Department, but can't demonstrate a 911 call, a body-worn camera, a police report, a CAT report. He can't present anything at all. And when I asked specifically as to where the damage took place, he couldn't clarify. His own attorney stood up and clarified where the damage took place, and the court itself had to ask for clarification. He does not remember what lane he was in. He indicated that the victim made payments to his Cash App, provided no documentation, and claimed that his Cash App had been deleted. Indicated that he didn't stay on scene and make a report because he was in fear of his life for his CDL and barber license, yet the defendant just admitted to a hit and run. He was involved in a crash and did not stay on scene. The defendant wants to submit to the court that the victim paid $80 for $3,000 worth of damages and only presents an invoice but no receipts of any payments. He indicated at some point that they were driving side by side on 166, but then later on says that the whole time the victim was driving behind him. There's conflicts in the defendant's own statements as to what occurred this date, but he wants the court to submit that he was acting in self-defense. The defendant even stated he didn't contact his insurance company. He did not report it because he had pay-as-you-go insurance. Another admission of not being lawfully insured and involved in the incident. And Your Honor took judicial notice of the state's Exhibit 1 that showed that this is not the first time this defendant has been involved in a vehicle involving an intimate partner. In fact, he pled guilty to a family violence battery where he used a vehicle to hit an intimate partner, Ms. Sharday Williams, and now he wants to claim self-defense. One moment. He also claimed that he had a cut finger, showed no documentation, no photographs, didn't go to the doctor. Doesn't know how many lanes were on 166, but claims he was switching lanes. Could not be honest enough to tell the court whether or not this was a first domestic incident involving a vehicle, admittedly lied and then later said that it was not the first incident. On cross-examination, the state proffered testimony that when the back of the RMP, when he was arrested, or the patrol car, that defendant made statements that he was with another young lady and that she was driving, and the defendant admits that she was there on scene. Yet neither defense nor defendant provided that witness testimony today. That witness would have been critical as to the facts of this case. One moment. And as far as Mr. Joseph Anderson, who's known the defendant for 20 years, wants to provide some character evidence about the victim being aggressive over toilet paper and claims that the victim drove by the barbershop days, maybe weeks prior. I asked the court to disregard that statement. He wasn't present at the scene and has no independent recollection of this incident. There's no 911 call, no report, no medical treatment, no evidence preservation, no insurance documentation, no contemporaneous self-defense claim. He left the scene. He has a prior similar vehicle conduct and now wants to assert after arrest that he was a victim of self-defense. At minimum, the testimony today establishes substantial factual disputes regarding who was the aggressor, whether the collision was intentional, and whether the defendant's conduct was reasonable. Those are jury questions that should be submitted to the jury for consideration. Therefore, immunity is inappropriate. Self-defense claims are strongest when they're made immediately, consistently, and contemporaneously to the conduct. Here, the defendant failed to report, he has flight, and he later developed this new narrative. At best, what we have is uncorroborated narrative that evolved over time, unsupported by any documentation or reporting. The court is required to assess credibility, facts, intent, reasonableness, and conflicting accounts of the force between the two partners. And Judge, there's just far too much factual contradictions between what the defendant's own statements and on cross-examination, the defendant outright lied or in state's position lied or gave conflicting information about what occurred on this date. This defendant bears the burden in this immunity motion. The burden is not on the state to disprove self-defense today. It's on his definitive or affirmative preponderance of the evidence that he acted lawfully in self-defense, and the defendant has not met his burden. One moment.
Okay.
If the court does not deny the state's motion, or I'm sorry, if the court does not grant the state's motion, the state does have a witness present, but the state believes that that witness testimony is not necessary for the court to make a decision, which is ultimately the central issue here. Credibility. This defendant tested not credible whatsoever. The court does not have to determine his guilt today, but at minimum, there are substantial factual disputes as to whether the defendant's use of force was reasonable. And for those reasons, the state will respectfully request the defendant's motion for immunity be denied and that these issues be reserved for a jury. Thank you.
All right. Mr. Jerome.
Yes, sir. I mean, it's an extremely low standard for the defenses to overcome a motion. And I'm from counsels, I thought this was a closing, but my understanding that this is not your closing. This is actually.
No, she said that was her closing.
Oh, this is your closing?
This is my, I'm not resting. I'm asking the court to make a decision that your motion is denied.
So
Well, I'm kind of, believe it or not, I'm going to get Madam Court over to send me something real down and dirty, make notes. I'm going to take it under advisement so that I can get these pictures in my head. I was trying to here, but.
Yeah, and I know it's difficult. To be honest with you, Judge, I actually went out to the site with my client to see the exit on 166 because it's very confusing. the way that he explained it. And I tried my best to give that visual, but I really, now I'm thinking in hindsight, I should have pulled up a Google map or something. But nonetheless, essentially, I mean, the defendant's testimony already states that this woman was chasing him. He was in fear for his life. There's any contradictory information in this is irrelevant. Talking about how many lanes there are on 166, or what's where's the Cash App, or any of this other stuff that the state is talking about is not relevant to the main claim here. And that the main claim here is that there's an immunity. Essentially, the state's victim in this case, and alleged victim in this case, came to Mr. Bibbins where he was at. She blocked him in. He still found a way out. She chased him for a while. He may or may not have another female in the car, but that's not relevant to it's not relevant to the claim of immunity. We understand that it does go to Mr. Bibbins' credibility, but I think that the court can judge Mr. Bibbins' testimony based off of what he's said and what he's done here today. I don't believe that he's sophisticated enough to have just conjured up this whole narrative about how he was chased in and rammed into, and then his vehicle got this damage, and then he had to go get it fixed and everything else. This is what happened to him, and he's just basically relaying to the court exactly what happened. Now, he may have some sexual improprieties or relational improprieties that he does not want to share with the court or others, or something of that sort, but that doesn't have anything to do with this allegation, this charge, and this accusation by the victim in this case. I mean, it's not uncommon for somebody of Mr. Bibbins' demographic to not want to call the police. There's often toxic relationships that people just don't trust the police, and they just don't, or they don't think they need the police. Sometimes, especially if men can be egotistical and think that they can resolve issues themselves, and it's not that big of a deal, type of situation. And so it's not uncommon for somebody to not call the police, if they don't feel like they absolutely have to. He got away. He eventually got away. Some of us would have said that, the second that she started following the first time, we need to call the police. But he did eventually, at some point, sit down, calm down, adrenaline settled, and say, all right, let me call the police. Let me make a report, whatever the case may be. Though he didn't, the fact that he doesn't bring up a police report, or the fact that he doesn't bring in the 911 call, doesn't diminish the fact that he's testified that he did call the police, and that testimony is uncontradicted. In addition to that, he's brought additional evidence of the character of the alleged victim in this case, who has shown on repeated incidences that she is at minimum, she's an aggressive individual, and at most, she's violent, and that this is within her pattern of behavior. He also testified that she was, that he believes that she was drunk, or that she's an alcoholic. And so it was possible that she was drunk at that time that this incident took place. And that testimony is also uncontradicted. The information regarding whether or not what the speed limit was is not relevant, and my understanding of this is that this was not necessarily a James Bond type of car chase where he was going 100 miles an hour, but basically he's going about his business and she's behind him constantly. And then at some point, he's starting to say, all right, I need to get away now. I feel like she's getting too close. I'm in danger. And then he starts to speed up. He starts to try to evade her, starts to swarm through traffic. But, it's not to say that it was a 30-minute Fast and Furious car chase, because that's not what the testimony is. The testimony is that she was following him, that he was driving, she was following him, and that he eventually, at some point, at the very end of this whole interaction, is when he sped up and then started evading her and swerving in and out of trucks and then making U-turns on the highway exit. And so he eventually did evade her and get away from her. And he did get out the vehicle. He did confront her. She did, he did say that she had a razor. That testimony has been consistent. He has consistently said that she ran into him. He said that he called the police as soon as this was over. He called the police and made a report that same day. That's consistent with what he was saying. Even when he was arrested, he was telling the officer, and basically the state tried to put some testimony into evidence, though the state can't testify. But by his own admission, he told the officer that she ran into him, and that this is not the first time that she's run into him, but that on the day of the incident and what they're discussing here, she ran into him. The previous family battery violence, I've already made my argument about that, but at this point, in reference to just a directed judgment on this, he's already presented his testimony, which is sufficient evidence. I've had numerous criminal cases where a defendant is convicted just on the testimony of the victim. And so testimony is evidence, just as, a phone call or recording of, a documented police report, whatever the case may be. And he's provided his testimony that he was in fear for his life, that the victim was chasing him, that he had to act in self-defense. Every defensive maneuver he made, his driving maneuvers, whatever he did, was all protected under the self-defense statute, and that there was no aggravated assault in this, and the court should dismiss this, or at least allow the state to present whatever witnesses they have to contradict some of what the defendant has said, because right now his testimony is uncontradicted. And if it stands uncontradicted, it's sufficient to find that he's immune from prosecution. Thank you.
Anything else from the state?
Other than, I believe the defendant has already added enough contradiction to his statements. The state does not need to bring, at least in our position, bring an officer to further underscore the contradictions that the court has heard for their own ears. That's all.
Okay, so yeah, I'm going to take this under advisement, like I said, and beg Madam Court Reporter for just a rough copy so I can keep track of some of the things that were said, figuring the layout of the car. I mean, I know the area, but
Yes.
it was getting a little confusing there for a minute. So would you guys like a couple of weeks to submit something in writing,
Would you like a proposed order or a brief or?
Judge, just to be clear here, the state is asking for a directed verdict. Are you?
No. I'm not.
You're considering the whole
No,
case?
yeah, I gotta go look at this stuff.
Okay, gotcha.
So, yeah, how long do you guys need? Let's be realistic, 'cause I don't know if you have kids, school's
Yeah.
getting out. I mean, I understand all that, so.
Exactly. School's getting out and I'm actually leaving this weekend, so if we could have at least 2 weeks, Your Honor.
Is that enough for you?
Yes, that's enough. And just to clarify, you need a brief, you need a proposed order, or both?
Yeah, let me stop with this. Excuse me, start with just a brief.
Okay.
All right.
And now let me see, let me give you a date. And please, y'all email me if, my calendar, if something comes up. I mean, I understand it happens.
May I release my witness?
Absolutely.
Okay.
Let me see.
Okay.
I had to get a calendar up here.
June 4th?
Is that going to be enough I don't know if you have kids or vacations planned or.
Mr. Jerome,
Yes.
is June 4th a good date? That's
Let me
2
see.
weeks
Hold
from
on a
today.
second.
Yeah, that's 2 weeks.
Yeah, I'm only leaving for Memorial Day weekend. I'll be back Wednesday, 27th. So yeah, June 4th will be fine.
I mean, are you
Can
sure?
we do June 8th just to be safe? Can I do June 8th?
What about you? I'll do June 11th. How about that?
And 11th.
June
Okay.
11th. That'll give you some extra,
That's perfect.
Yes, Your Honor.
because I know somebody's going to have some kind of plans. and go,
Something's gonna happen.
Yeah, it happens. And encourage all lawyers to take that break.
Yes, thank you.
Your
All
Honor,
right.
you just want us to email it to you, maybe CC Ms. Woods as
Sure.
well? Okay.
Sure.
June 11th. All right.
Thank you, Your Honor. May I be excused?
Absolutely. Thank you, Madam Court Reporter. Thank you, Mr. Surge.
Thank you, Judge. Let me ask you, you got both the letters that I sent you, I gave you, right?
Yes.
All right, and then she also
Have
sent.
y'all given all the,
What started as a self-defense hearing quickly turned into a dramatic courtroom battle over a toxic relationship, alleged stalking, and a dangerous car chase. The defendant, Darrell Bibbins Jr., took the stand and described a relationship that he claimed had been troubled for years. According to his testimony, he had previously filed multiple protective orders against Ashley Wimby and had reported several incidents